All right, we're back to give you a case law update on some of the bankruptcy cases that have been decided in the last year or so. We're not going to follow the materials exactly. There may be cases there that are of interest to you. There may be cases there that are not of interest to you, and I'll let you make that decision on your own. We do, on the first page of the outline, I wanted to just highlight for you the substantial activity by the United States Supreme Court in the last year. As you can see, there are 5 cases there related to bankruptcy. There are 2 more that are on appeal right now that should be coming out on the June release of opinions, if not before, that relate to actual fraud and some claims issues. So you're going to want to take a look at that, particularly coming up in the next year or so from the Supreme Court will be a decision on the equal opportunity credit issue involving the signature of a spouse on a guarantee just by virtue of the marriage, not by virtue of the independent ability to pay. The Iowa Supreme Court has addressed that issue, and so has the 8th Circuit, and that is the case that is on appeal. There's a split in the circuit, so it might change Iowa law in large part. Until it gets up, through the U.S. Supreme Court, we won't know. So keep an eye out for those things, and Judge Nail and I are going to cover a few of the cases here, not in huge detail, in deference to Judge Nail's remarks about winning your appeal or not winning your appeal. We don't want to drudge here for 45 minutes giving you every detail of every case, right, Judge?
Correct.
All right, so this is going to be a bird's eye view. If any of you have any questions, what we're going to try and do is highlight some of the facts and issues that resulted in the holdings of the 8th Circuit and Bankruptcy Appellate Panel. If we started going below that level, we'd be here until next week discussing the various cases that judges have decided in the bankruptcy courts across the 8th Circuit and even in Iowa, because there's a large difference. The bankruptcy cases are fact-intensive, and so a lot of times you're going to have differences in holdings dependent on those facts rather than on the exact application of the law under similar circumstances. So let's first talk about standing. That's one of the issues that we're going to dovetail back to the how to lose your appeal or how to win your appeal, depending on how you want to frame the question. In order to successfully appeal, you first have to have standing to appeal. I mean, nobody can come in just off the street and say, I didn't really like that decision you made, and so I'm going to insert myself into this court process and appeal this decision. And the O&S trucking case is one of the cases that is really unique in this regard, and lawyers like to avoid additional work, taking from Mr. Critelli's comments. There's just so many hours in a day, there's just so much money in the client's retainer or pocket. The O&S trucking case was a Chapter 11 case that involved an issue that was disputed as to the value of some trucks and a security interest. And that was the subject of a prior appeal. In this particular case, the debtor was appealing from 3 orders issued by the bankruptcy court, one of which had been dismissed on appeal as interlocutory. It first was the order determining the secured claim, which went to the valuation of the truck, an order denying reconsideration of that claim, of that ruling, and the plan confirmation order. Now, the 8th Circuit said that they weren't going to consider the orders on secured claim and the reconsideration order because they were interlocutory. So the 8th Circuit stated that those issues merged into the plan and its confirmation and could be considered on appeal. The problem in this case is, and we have a rule here, and it's applied in other districts, as I mentioned earlier, that in order to appeal an order, you have to have an adverse ruling, right? You don't go appealing orders that are in your favor. And in this particular case, what the parties did is they apparently agreed to standing for appeal. And the 8th Circuit said, you can't do that. If you're going to want to appeal a confirmation order, you must object to your own plan. Okay? That's the rule. So you may get through confirmation, but what has to happen is you have to file an objection to the plan, and the bankruptcy court has to overrule that objection, confirm the plan, and then you appeal. And then you get to discuss the secured value, the motion to reconsider, and plan confirmation. Here what the debtor did is they included in their plan, well, we're going to appeal these issues. And the 8th Circuit said, well, you can't do that. You can't agree to confer standing. Once the plan got confirmed, you won. You have an order in your favor. The whole goal was to get a plan confirmed, and that has occurred. So you can't appeal that order. What do you think of that?
I almost felt sorry for these attorneys because the first time up, as Judge Chodine indicated, they tried to agree that we could hear the interlocutory appeal. They wanted to agree to that. If they hadn't thought about it. In oral argument, we asked one of those questions that completely silences the room. Is this a final order? And the blank look on both sides, and, well, no, but we'd like you to hear it anyway since we're here. If you go back to our materials and what we talked about this morning, that's not a basis for our granting hearing the interlocutory appeal. So we sent them back down. They come up again, and this is the case where they came up again, and they wanted to this time agree that they had standing, even though you can't agree that you have standing. I wanted to emphasize one point. There was the point made that the BAP said that the order turning the secured claim and denying the motion to reconsider it weren't final. Judge Kressel wrote the opinion. Judge Kressel from Minneapolis wrote the opinion, and he's very adamant, and I've come to agree with him on this. And an order that is interlocutory does not become final when you appeal, when you finally appeal from the final order. The earlier order is still interlocutory, but you can ask the court to consider it as part of the appeal from the final order. All orders that lead up to the final order are brought into the final order. And Judge Kressel was trying to make the point that, because these guys were now claiming that these were final orders, his point was, no, they're still not final orders. They're interlocutory. We'll consider them in connection with the final order. But wait, no, we won't, because you don't have standing. So it was more an esoteric point of law than saying that they couldn't be considered, because we recognize that they could be considered in considering the final order, on the confirmation order. What do I think about this? We're not recording this, right? The expert is never going to see me saying this.
Unless they sign up for the webcam, but most of them are over at the investiture this afternoon.
Legally, I understand it. Okay, I understand the reasoning behind it, and I feel the same way I feel about the Chapter 13 procedure that we've talked about before. You file your plan, you object to your plan, you appeal from the order overruling your objection, sustaining your own plan. That's a difficult thing to understand. It's no easier for us when we're trying to consider the appeal. We have to wrap our heads around the fact that we're really not talking about the plan that got confirmed. We're going back in time to the plan that got denied. And the arguments that are framed in the brief are hard for the attorneys to frame. They're equally hard for us to get our heads around too. So I understand the law. Technically, I can't quibble with the law, but man, I wish it were just you could appeal from an order denying confirmation. Because we all know that really does kind of end that. I mean, technically, yeah, the case is going to go on, and that's where the argument comes. You have to. It's not a final order. But as a practical matter, we appeal lots of stuff. We have lots of things in bankruptcy cases that don't dispose of the case, and the hear those appeals. So I'm torn. I mean, I understand it, but it's a problem for practitioners.
I think that I will go on the record as saying I almost always defer to Judge Kressel on matters of.
It's a wise thing to do.
Yes, on standing.
And I encourage all of you to do the same. It will be one of his opinions.
But I will also say that his discussion about interlocutory and that now it all gets swept in and it's final and then you come back around to whether you're a party agreed, it's just more sleep to lose than I'm willing to go through. So I think, suffice it to say, you have to have some kind of damage or grievance or something that is going to specifically affect your financial condition as a result of the ruling, I think is a pretty good standard. If you don't have that, then you're probably not going to have standing.
Right. The court has to say no to you.
That's a good way of looking at it, too. And so let's look at Robb versus Harder. That's also in the case. This was a case where there was a conversion from Chapter 7 to Chapter 13, and the Chapter 7 trustee filed an administrative expense claim in the Chapter 13 case saying, you know, I'm owed $450 for services that I rendered in the Chapter 7 case. So they're not necessarily coming in as an administrative claim, okay? Let's think about it in a different fashion and not get wrapped up in the concept of what the priority of the trustee's claim is. The trustee says, you know what, I expended $450 and the debtor has now filed a Chapter 13 and they proposed a plan that says they're going to pay their unsecured creditors $590 a month, all right? It's not going to be 100% distribution probably, but the debtor objects to the trustee's claim. And the issue is, well, if they're going to be paying $590 into the plan anyway, and the trustee's claim doesn't change that, how are you aggrieved? You don't have a pecuniary interest in how it turns out. Whether MasterCard or the trustee gets paid a pro rata share of whatever you're putting into your plan doesn't matter to you who gets it. The important thing is you're still paying the same amount of money. Now, so that's if the debtor objects, and the court, you know, decided that the debtor didn't have standing to object to the trustee's claim. What do you think about another creditor coming in and objecting?
Well, I think clearly the creditor would have standing, and I think the debtor would have had standing if it had been a 100% payment plan. If the plan said, I will pay 100% of allowed unsecured claims, then that would be a pecuniary impact on the debtor because he or she would have, and I guess it's, well, whatever, he or she would have to pay more into the plan if it were a 100% plan.
The takeaway from this person aggrieved standard or pecuniary interest is probably best explained this way. If the money doesn't eventually flow back to the debtor, you don't have standing. There has to be surplus funds of some sort in a Chapter 7, or as Judge Nail says, you have to have a 100% plan, and then the debtor has to stay in Chapter 13 longer or more, right?
Right.
So if there's no benefit to the debtor under either one of these, then you probably don't have standing. Okay, let's talk a little bit about some claims objections. There has been widespread litigation, or at least an uptick in adversary proceedings where debtors allege there's been a violation of the stay or violation of the discharge injunction, and the cause of action arises under the Fair Debt Collection Practices Act. And so you're dealing with two different provisions. Do you have a violation of the stay or the discharge injunction? And the facts that give rise to that potential violation must meet the FDCPA standards. In Gatewood versus CP Medical, the debtors filed a Chapter 13, and a company that had been assigned collection of a medical debt, CP Medical LLC, as they were invited to under the notice filed in the bankruptcy case, filed a timely claim. That claim indicated when the debt was incurred and the amount of the debt. Now the debtors came in later. They didn't object to the claim as it was filed, and there are specific claim objections that can be raised by statute, one of which is the claim cannot legally be enforced. None of those objections were filed. So the debtor comes in later and says, oh my gosh, you know, CP Medical, you have breached the conduct required under the FDCPA because you filed a time-barred claim that cannot be enforced. And so they went instead through the FDCPA, not the claims objection process, and essentially the debtors alleged that the medical services that were provided that underlie the claim were outside the 2-year statute of limitation for enforcement. So the bankruptcy court, and this happened to arise in Arkansas, but I think several states have these statute of limitations of, you know, a couple of years on medical debts and whether you can sue on them to enforce. And the bankruptcy court granted summary judgment in favor of CP Medical. And essentially, the bankruptcy court said that the conduct of filing a claim does not rise to the level of actual or threatened litigation. When it came up to the BAP, they looked at all of the elements of what needed to be met under the FDCPA. And Judge Saladino wrote for the majority, and his observation, or the panel's observation, was filing a proof of claim in a bankruptcy case is intended to result in some recovery for the creditor. So clearly, it's an effort to enforce or collect a debt. And that's close enough to litigation that they meet that prong. The next thing is whether the filing of the proof of claim for a stale debt was false, misleading, deceptive, unfair, or unconscionable. And well, not every filing of a stale claim, could automatically be a violation of the FDCPA. If you filed a false proof of claim or a proof of claim that included or excluded information that was relevant to the status of that claim, yeah, you might have a problem under the FDCPA. So the problem became, when the BAP panel looked at it, is did this fall within unfair, deceptive, misrepresentation? And the BAP decided that the claim was not misleading, it was not unfair, and it was not unconscionable. The claim clearly did not misstate the date the debt was incurred, and it also did not try to hide the fact that the debt was otherwise stale. And so instead of saying it wasn't a collection of a debt, the BAP actually went a little bit further in its analysis and said, there's nothing wrong with this claim. You could have used the claim objection process, you didn't. But when somebody files a stale claim, that just means it can't be enforced through litigation. That doesn't mean the debt still doesn't exist. Points to add?
Well, mountain meet molehill, as far as I'm concerned. If someone in here knows more about the Fair Debt Collection Procedure Act than I do, which, by the way, puts the bar at you've read it, maybe you could help me out here, but I'm assuming that there must be attorney fees that are recoverable under there.
There are.
And that's the only reason this was done. We routinely have objections to stale claims, and I routinely sustain the objection, and the claim goes away. It's a 1.5-minute hearing.
But there's no attorney's fees for filing an objection to claim.
I understand.
And there are no post-petition damages that can be awarded to your client.
I understand, but there were no real damages here. They filed a claim that was facially wrong. It was easily objectionable. It was easily sustained. It's gone, but we make a mountain out of a molehill. There was a question over here.
Well, I was just wondering, Judge Levine started to answer it on that. It seems to me that if that was in fact a violation of that, there are statutory damages. You could get $1,000 per violation.
Right, and you know what?
Trying to get something for the estate, maybe.
No, because it always has to happen post-petition. You file claims post-petition, you violate the stay after the petition, the discharge is entered post-petition. So that is all debtor's money if there's a violation. What?
So they were trying to get it from themselves, didn't they?
In a 13, what they were doing was they filed it, that was a violation of the stay that they were arguing, not a violation of discharge. That happens in 7s more frequently. A little bit of background, Mr. Norton, pardon me. Long day, longer week. We have, and I know better than that. These people filed like 13 adversary proceedings related to the FDCPA and violation of the stay in this Chapter 13 case. Yeah.
Just kind of go back to your standing issue. If you have any question, if the debt is, if you're not attempting to collect the debt from the debtor, then is that, I guess, does the debtor have the standing to claim that in a 7? I mean, this is a 13, so that standing issue doesn't seem to be the same, but I guess I wonder, was that argued, or do you know about that part?
Well, it wasn't argued by the parties, but it was lively argued among those on that panel.
Oh, yeah.
Wait a minute, those conferences are confidential.
I know, and so, no, if anybody repeats that, I don't know, you're in big, big trouble. But yeah, that was a question. I think that's a legitimate question, but it wasn't raised by the party.
I think it has been raised in other cases around the country in the 13 context, not the 7 context, and they weren't harmed, not collecting from them.
Okay, reaffirmation agreements. You know, you hardly ever think about these because the form is official, it's spit out. Creditors normally prepare them, not creditors' attorneys or debtors' counsel. But, you know, you need to remember that there are certain things you can and cannot do with regard to reaffirmation agreements. In the 8th Circuit, we followed a long line of cases that said you can't fold in discharge debt into a new obligation unless there's a reaffirmation agreement. Okay, and there's been a split in some of the cases, and it's highly fact-specific. I think Ford versus Dubois is one where the debtors rolled in some debt to a reaffirmation agreement, and then they couldn't pay it, and then they went and alleged that the creditor, you know, had violated the discharge injunction by trying to collect under that obligation. So in Venture Bank versus Lapidus, this case actually came out of Minnesota, and it was a Judge Dreyer case before she passed away, and she focused the issue on 2 things. In order to get repayment of a debt post-discharge, either 1, the debt must be enforceable under state law, or it must be reaffirmed. And essentially what she was talking about on this enforceable under state law issue was, and I remember back in the day, you know, we'd tell people, oh, you don't need to do a reaffirmation agreement, just enter into an agreement with the creditor. All right, so that law has changed over time, and right now the current status of the law in the 8th Circuit is you don't have a reaffirmation agreement, you're out, and you have to use the right form. A cautionary tale for folks that might represent creditors. This problem arose because the bank didn't, or the credit union or the bank didn't want to hire a lawyer. And one of the bank people opened their file drawer, pulled out a reaffirmation agreement that was, you know, I don't know, 4 or 5, 6 years out of date, filled it out, sent it to the debtor. He signed it. He sent it to the debtor. The debtor then calls his attorney and goes, what do you think I should do with this? And the debtor's lawyer said, nothing. We're not signing it. We're not presenting it to the court. We're not doing anything. So the bank then, rather than getting the correct form and maybe figuring out how it would work, they then started doing these extensions of notes. And they started calling the debtor. And the debtor, the background of this case is the debtor was trying to get the bank who held the 3rd mortgage on his homestead that was underwater to refinance the first 2. And they kept dangling the carrot of, well, we might do that, but we want to see if you're creditworthy first. And if you just pay us 6 months worth of $5,000 a month, then you'll be creditworthy. Well, then the banker, you know, not satisfied with $5,000 a month or whatever it was, goes, boy, it would sure be nice this month if you could think about paying us a little extra on the principal. And what the 8th Circuit decided is, first of all, you can't, that's not voluntary. You can't be calling somebody 2 or 3 days before their loan payment's due and saying, how about throwing us another $300 this month? That's not voluntary, it's coercive. especially when what you're holding, in the back pocket is, well, if you don't, that there's kind of this inference that if you don't do that, we might not decide to refinance you. Well, in the end, the house got sold, the bank didn't get any money, and then what they did is they went to state court to enforce the extensions of the loan. And that's when everything blew up. And they came back to bankruptcy court for alleged violations of the discharge injunction. It was appealed to the district court in Minnesota, where they found also that it was not voluntary. Went to the to the 8th Circuit. And the 8th Circuit, really, the takeaway from this is you got to have a reaffirmation agreement. None of this sign deal stuff. Do you see something different in that case?
Can't comment. I got one that I've got under advisement right now.
And that would be top secret. Okay, so.
It'll be out soon.
All right. Absolute priority rule in individual Chapter 11 cases, and before all of your eyes roll back in your head and glaze over, we can make this really simple. All right. Absolute priority rule means that creditors have to be paid in a certain priority, and in full, the debtor can retain their property. It comes up most frequently in Chapter 11. It was written out of Chapter 12. That's why farmers don't normally have successful Chapter 11 cases, because their creditors have to agree to the treatment that's being proposed. So it works more like 13. When an individual files Chapter 11, what they, you can't get into the mind of Congress. That, would be, total down the rabbit hole. But what you could see happening when they drafted this individual Chapter 11 is that they wanted it to be most like 13, that creditors couldn't come in and prevent a debtor from repaying them. All right, well, in this Heritage Bank versus Woodward, as a practical matter, the majority rule now from most courts is you have to pay your unsecured creditors in full unless, if you want to retain property. And that includes post-petition property. So essentially what that has turned on its head then is an individual's inability to get a plan confirmed if they've got a big creditor that's going to vote against the plan.
And this all came about because of the BAF-CFA amendment that added Section 1115 to the code, which is worded, and I won't get the wording exactly correctly, but it's something like, in addition to the property specified in Section 541, property of the estate, individual debtors stated in Chapter 11 shall include, and it's basically post-petition income, which, as we know, is excluded otherwise by 541. And so courts were saying, well, it says in addition to, so we're creating this new kind of estate, therefore we don't have to worry about absolute priority. Or it's really in addition to 541, so we do have to worry about it. My takeaway from it is all day a very divisive split of authority in South Dakota. I ruled one way the first time, and I ruled the other way the second time. I was right the second time, but I was very happy when it went up because I knew that no matter what happened, I was going to be right.
And people, one way or another,
one
right?
One way or another.
So anyway, if you're handling Chapter 11 cases for individuals, I think that people who, fail the means test under 13 think a Chapter 11 is a good option, but the rules are going to be different, and they're going to be, specifically different now. Student loans, we're not going to get into too much, but on the Conway case, this is the second appeal on this case. So, the debtor, Ms. Conway, was pro se and prolific in her litigation. She appealed the undue hardship issue, and it went up to the Bankruptcy Appellate Panel. And in this particular case, it was one of those Nelnet kind of loan places that rather than consolidate the loans, they did like 18 individual loans. And the Bankruptcy Appellate Panel a couple of years ago said you have to take into account whether she can pay each and every one of those loans. You can't just lump them all together for purposes of, is there an undue hardship? So it got remanded back to Judge Surratt State, who then had to decide, where do you begin looking at the evidence? Because what the debtor wanted to argue is, you know what, I've lost income since you last heard my case. So I think I should be able to come in and now present to you new information about my income. Because, you know, if you didn't think there was an undue hardship before, let me tell you, there's one now, okay? So, two things. Number one, make sure you look to see if the loans are consolidated. Because if they're not consolidated, it's fair to argue that your client can afford to pay this loan, but not this one, all right? So, you know, you can almost break it down like it's a partial discharge. You know, maybe she can't repay $100,000 worth of debt, but she can pay this loan of $25,000. There's some vagaries and some inconsistencies that you've got to work through there, but that's becoming more and more common across the country in terms of litigation.
And the biggest vagary for me is your $100,000 of student loan. What if you have 10? They're all $10,000. She can repay $10,000. Which one do you
Well, that's
discharge?
why you get the big bucks. So, you know.
Yeah. I haven't confronted it, but every time, and it is, we and the BAP is long held since like 1999 that you had to look at each loan individually, and that sounds great when you hear it, but and we provided no guidance. I wasn't on the panel then, I don't know. We provided no guidance as to how you do that. But if I'm one of the $10,000 loan creditors, I want mine discharged. I want you to be able to pay the other 9. But if there's 2 or 3 student loan lenders, they're all making the same argument. I don't know how we resolve that.
Well, and I think, you know, so the takeaway is don't bring one of those cases in front of me or Judge Nail. Go somewhere else, and maybe they can provide guidance. But I do think this case does provide some.
Well, what you do is you bring the big ones, you bring them individually, and you take the big ones on and you get them discharged. And then you
Leave the other
don't go after the 1 or 2 that are small.
The other way that you could frame your argument is the way Judge States did, is she said, well, first of all, I'm not going to look at your expenses and your income now. Those are set at the time of trial, and that's our record. We're not reopening the record.
Wait a minute, you only get 1 chance to make your record?
One chance.
There you go.
One chance. But, you know, I mean, I think the debtor was trying to say, you know, well, if you look at this month versus this month, and, you know, if you did it now as opposed to then, the trial record is the trial record. It wasn't remanded for a new trial. It was remanded to determine whether or not there was an undue hardship. So Judge Surratt went back and looked at the expenses and the income that were in place at the time of trial, and she came up with a number that the debtor could pay. And then she picked which loans fit those numbers. I don't know whether that's right or wrong, but I don't think that was appealed. I can't remember whether that, maybe the time's still running and Ms. Conway's working on her brief. I don't know. I want to talk about the exemptions under Dittmeyer versus Fosny. This is a Kansas or a Missouri statute, but I think some of Iowa's statutes are similar. A distinction between the right to receive an asset or a payment versus whether it's still exempt after it's received by the debtor. So what you've got is a fairly thin line of statutory construction there. The dispute on the appeal, you know, it had to do with income tax refunds or public benefits. The right to receive a public benefit is different than an exemption in a public benefit. So the issue on this appeal was whether the right to receive a public assistance benefit terminates when the debtor receives the benefit prior to filing. All right, so in Iowa, right, we have wages retain their character in bank accounts. So you can, if somebody hits a bank account for a garnishment, you can say, well, those are my wages, and so you can claim them as exempt. So in this particular case, the issue was the woman or the people that were filing bankruptcy were asked to turn over their earned income tax credit or their additional child tax credit or whatever it was. Because it was paid prior to filing and they still have those funds, not exempt. Because it's the right to receive it, the 8th Circuit said. Once you receive it, it's no longer a right to receive. What do you think of that, Judge Nail?
I think it would have made a great retainer for the attorney, and then it was spent and it couldn't have been collected. I don't know how that was missed.
I don't either, but it was. Okay.
Will we're out of time. We can't talk about
Hardy versus Tink.
We're out of time.
You know, Judge Nail said
I wrote the opinion that was reversed by the 8th Circuit. Get it out there.
Well, and it's worse than that. I was on the panel with him that reached this conclusion, and then I had a case that was presented differently to me with the exact same issue, and I reversed myself, and Judge Nail as well. And then the 8th Circuit heard it. This has to do with the exemption of additional child tax credit, and it also came out of Missouri. Without going into the details of this case, most of you probably are aware of the case in Iowa, or at least in the Southern District now, which allows the exemption of additional child tax credits. But this case is a perfect example of arguing policy on appeal. And usually judges don't go listen to oral arguments of cases that, you know, are on appeal, but I couldn't help myself on this one. And Judge Malloy wrote the opinion for the 8th Circuit, and this was one of the arguments presented by the parties to us, and we didn't, you know, it wasn't discussed a lot in the BAP opinion, but Ms. Hardy's lawyer said if it's a public assistance benefit and my client is a member of the public, therefore it is a public assistance benefit to her. Because she made, like, you know, I mean, I don't even know how much money she made. That was not a fact that was given to us. So he went on to the 8th Circuit, and Judge Malloy, as he was going down the path of this argument, just said, you better move on, counsel, that's a non-starter. And just said, you know, I mean, they do things like the 8th Circuit. You know, we let them argue.
We're
right?
much more polite than
yes,
that.
We are. Kinder and gentler at the bankruptcy appellate level. I want to just draw to your attention the sanctions cases. We're not going to discuss them a lot, but you know what? There was a lot of them lately.
There were.
We've had a lot of sanction cases, and that's a bit worrisome. Some of them result from action taken by judges sua sponte to impose sanctions. Some of them have come about by representations made by counsel on behalf of their clients to improve their case that aren't quite technically correct or true. And others are the fights between attorneys and what action, you know, is allowed as a safe harbor under 9011, and, you know, he said, she said, but what he said was worse, and those types of things. And I guess I don't know whether it happens in real life, but for us to have 4 or 5 sanction cases over the course of a year, I think is a lot.
I sanctioned an attorney twice in 10 years. It was the same attorney for the same offense, and 2 years apart. I mean, obviously the first sanction didn't take because I had to do it again 2 years later. I haven't had to do it again since, and I have done nothing under 9011 since BAP-CIPA. It's not been it scared so many practitioners out of bankruptcy when it was adopted, but I have not seen it be an issue for us.
None of these cases are the result of counsel not knowing what they're doing under BAP-CIPA. These are just blatant issues with regard to what is appropriate conduct between an attorney and the court, the attorney's duties to the court and their client, and, you know, and between the parties. But I am happy to report that none of these came out of Iowa.
Or South Dakota.
Or South Dakota.
Or Nebraska.
Or Nebraska.
Or Minnesota.
Or Minnesota. No, I think one of them did come out of Minnesota.
Missouri
and Arkansas is, you know.
Well, everything comes out of Arkansas. All the things. I don't know what's going on down there.
No, and Missouri too.
They do not like each other in Arkansas.
So unless there are any questions, that's the update. Thank you.